One of the most significant battlegrounds in modern intellectual property law sits at the intersection of artificial intelligence, identity, and trademarks. As AI becomes increasingly capable of replicating voices, faces, and other personal characteristics, businesses, celebrities, and rights holders are looking for new ways to protect identity from misuse and deepfakes. We've already seen how realistic AI-generated content can be presented in a false way. During Ireland's recent presidential election, a deepfake news report falsely suggested that candidate Catherine Connolly had withdrawn from the race before voting even took place. In Europe, protecting identity presents particular challenges. Unlike the United States, there is no standalone personality right that gives individuals clear ownership of their image or likeness. As a result, many famous people and their advisors are exploring whether trademark law can provide an alternative form of protection.
Recent examples include sports stars Luke Littler and Cole Palmer seeking to register facial images as trademarks, while Taylor Swift's management company has applied in the United States to protect spoken phrases associated with her voice through soundmark registrations. These applications are part of a broader effort to secure legal rights over commercially valuable aspects of identity before AI-generated replicas become even more sophisticated. However, trademark law was never designed for this purpose. European trademark systems require a sign to function as an indicator of commercial origin, and it remains unclear whether voices, faces, and other identity traits can consistently satisfy those requirements. The challenge becomes even more complex when digital twins and AI-generated replicas are involved. Brands are already experimenting with AI versions of models and influencers, raising new questions around ownership, consent, and control. Importantly, trademark law is unlikely to provide much protection during the training phase of AI systems, where photographs, recordings, voice samples, and other personal data may be used to train AI models. Its value is more likely to emerge later, when AI-generated content is used in ways that suggest endorsement, affiliation, or sponsorship without permission.
In Denmark, there is a proposal to have voice and likeness protected as a right under copyright laws, and there may be further developments in the EU on that. The key operative part of the proposal is consent from the person imitated before the deepfake content is made available. For businesses, the message is clear. AI due diligence can no longer be separated from intellectual property, privacy, and identity risk. Organizations should be reviewing contracts, assessing rights in training data, and considering how valuable identity assets are protected. The law is still evolving, and many of the most important questions remain unanswered. But as AI-generated content becomes more sophisticated, identity itself is emerging as a commercially valuable asset, and trademarks may become an increasingly important line of defense.